Hi, Sri.
Hi, Jess.
So we're chatting today about the commercial rent coronavirus bill and looking at it from an insolvency perspective. So we follow on from Joanne and Emer's excellent web chat last week, which was focusing on the property elements. So the bill was announced on the 9th of November of this year, and it looks to continue the support given to commercial tenants during the coronavirus pandemic by ring-fencing certain rent debts and proposing a new arbitration scheme by which tenants can be relieved from those rent debts. So Sri, why don't you kick us off? What rent debts are covered by the bill?
Well, the bill refers to protected rent debts, and a protected rent debt is a debt due under a business tenancy, i.e. under the Landlord and Tenant 1954 Act. And that's where they occur where all or part of the business carried on at the rented premises was forced to close as a result of the government COVID restrictions, and where the rent debt is attributable to a period of occupation within what's defined as the protected period. And that's from the 21st of March 2020, so just before COVID got really serious, until either the 18th of July 2021, which we all know as Freedom Day, when all the restrictions were lifted, or an earlier date if that particular business was lucky enough to have the restrictions lifted sooner. So that's protected rent debts and what they are. So this new scheme is all about arbitration. Jess, why don't you tell us how the process works?
So either the landlord or the tenant can refer their dispute over payment of the protected rent debt to arbitration, and they have 6 months within which to do so. And the arbitrator has really wide powers. So if they determine that the tenant's business is viable, they can write off the tenant's debt altogether, or they can give the tenant time to pay over a period of up to 24 months, so long as that is consistent with the landlord's continued solvency. So Sri, a really key part of this bill is its moratoriums. So how do they work?
Well, Part 3 of the bill imposes a whole suite of moratoriums on insolvency arrangements and on certain other remedies that landlords might wish to pursue in relation to protected rent debts. However, landlords are going to have free rein to pursue pre- and post-lockdown arrears and to pursue all arrears for tenants who weren't mandated to close or who are licensees rather than tenants under a business tenancy. But going back to the moratoriums, the moratorium period, as defined in the bill, begins on the day that the bill is ultimately enacted, whenever that will be, and it ends either when the 6-month arbitration window closes, if there's been no reference to arbitration, or if there has been a referral, when that arbitration concludes, and that includes the final determination of any appeal. In relation to winding up petitions, however, the moratorium provisions aren't going to come into effect until April Fool's Day next year, and that's the day after the current restrictions on winding up petitions are due to expire. And the current restrictions on winding up petitions apply to any business rent, which is unpaid by reason of a financial effect of coronavirus. And the restrictions that would be introduced under the bill, if it becomes law, are going to be much narrower, as they only apply to protected rent debt. So that's winding up petitions. Now, Jess, you've been looking at the bankruptcy side of this. How do moratoriums work for bankruptcy petitions?
Yeah, so some bankruptcy petitions are going to be caught by the bill's moratorium. So the bill prohibits the issuing of a bankruptcy petition based upon a statutory demand or a debt claim which is served or issued on or after the 10th of November and which relates to a protected rent debt. And that extends all the way up to the end of the moratorium period, which Sri, you were just telling us about.
And the bill isn't probably going to be passed until next year, is it? So do you think in the meantime the judges are going to start applying these provisions?
Well, that's what we saw with the bill which became the Corporate Insolvency and Governance Act 2020. But even if judges don't start applying the provisions of this bill, the bill itself contains some really powerful provisions in respect of bankruptcy orders, which are made between the 10th of November and when the Act comes into force. So it says that if the bankruptcy order would not have been made had the Act been in force, then the bankruptcy order is void.
Sounds like it's going to be very unattractive for a landlord to attempt to start a bankruptcy process with that looming. If a bankruptcy order is made, which then ultimately becomes void, where does that leave a trustee in bankruptcy?
So the bill says that if a bankruptcy order is made void, then the official receiver and the trustee in bankruptcy are not liable for acts done under the order. But it subjects them to a fairly onerous obligation in that if it appears to them that the bankruptcy order is void, and it might be appropriate for the court to make orders restoring the position to what it was before the petition was presented, then they must refer the matter to court. And interestingly, the bill makes no provision for the costs and expenses of the official receiver or the trustee in bankruptcy in respect of a void bankruptcy order. So an insolvency practitioner should think very carefully before accepting an appointment under a potentially void bankruptcy petition. So that's bankruptcy petitions. Are there any other insolvency moratoriums which we've not covered?
Yep. So the bill also imposes moratoriums on proposing CVAs and IVAs in relation to all or part of the protected rent debts. Although it's important to note that those moratoriums cover a different and shorter period than the moratoriums on winding up or bankruptcy petitions. So the moratoriums on CVAs and IVAs stretch from the appointment of an arbitrator under the bill to either 12 months after they've made a decision regarding relief from payment, or the day on which an award of relief from payment is set aside on appeal, or the day on which the arbitrator dismisses a reference to the scheme, or the day on which arbitration proceedings are ultimately abandoned or withdrawn by the parties. So that's a bit of a mouthful, but we've covered moratoriums. Are there any other parts of the bill which have an insolvency focus, Jess?
Yes, so the bill excludes from the arbitration scheme any protected rent debts which are subject to a CVA or IVA or a compromise or arrangement which has been approved by the court and which relates to a protected rent debt.
And does the bill say anything about a situation where a CVA or an IVA has been proposed but is still awaiting a decision?
It does. So if a CVA or IVA has been proposed or an application has been made to court for sanction of a compromise or arrangement, and they relate to a protected rent debt, then the landlord or tenant can refer the matter to arbitration, but the arbitration process is paused. So no arbitrator is appointed until the outcome is known.
Interesting. Well, it's certainly going to be interesting to see if and how the bill evolves as it moves through Parliament. I'm sure we'll be back once we know exactly what the Act says. Thank you, Jess, and thank you everybody for listening.